Now, programming from the Illinois Channel, an independent, nonpartisan corporation formed to provide nonpartisan coverage of Illinois state government and other public affairs events taking place across Illinois. For more information on the Illinois Channel, please visit our website at www.illinoischannel.org.
Just ahead, Illinois lawmakers call for a criminal investigation to look into how millions of dollars were misspent on a program that had been designed to combat neighborhood crime. Then, in about 25 minutes from now, we speak with Representative Tom Cross about his race for the Republican nomination for state treasurer. In about 30 minutes from now, we speak with the head of the NFIB of Illinois about the proposal to raise the minimum wage and hear what impact that would have on small businesses. Then, in about 40 minutes from now, we talk to a representative of the American Lung Association and get an update on proposals to limit smoking in outdoor locations, including college campuses. Following that, in about 55 minutes from now, we go to Chicago, where our contributing correspondent Jeff Berkowitz and his guest, the National Review's Ramesh Ponuru, give an analysis of possible Republican candidates seeking the nomination for president in 2016. And finally, in about 1 hour and 20 minutes from now, we talk one-on-one with Stephen Phillips, president of the Illinois Trial Lawyers Association, and hear why he says trial lawyers remain one of the primary defenders of average citizens' rights against powerful interests. That's all just ahead after this brief note.
The Illinois Channel salutes our advisory council members, leaders in business, education, law, medicine, and other fields from across Illinois.
Hi, I'm Bill Fleishley, Executive Vice President of the Illinois Petroleum Marketers Association. I'm also proud to say that I'm a member of the Illinois Channel Advisory Council. Proud because the Illinois Channel not only connects you and me to Illinois legislative hearings on major issues, or press conferences by the governor or the Supreme Court cases, but just as important as covering government functions, the Illinois Channel also covers leaders outside of government. They allow organizations like the Illinois Petroleum Marketers a chance to share our views with the citizens of the state on the impact proposed laws will have on Illinois businesses and Illinois consumers. Of course, you can always accept our viewpoints or reject them, but at least with the Illinois Channel, you will hear them. And because their coverage is unedited, it won't be just a passing soundbite. I'm Bill Fleishley. I watch the Illinois Channel because I want to keep current on the leaders and the issues affecting our state. I hope you do too. The Illinois Channel, it's there for all of us.
Next from the state capitol, Republican lawmakers hold a press conference to explain why they want a criminal investigation launched into how tens of millions of dollars were spent on a program that was supposed to combat neighborhood crime. This runs about 20 minutes.
Okay, thank all of you for coming out today to discuss and view the very disturbing findings of the audit of the Illinois Violence Prevention Authority. Just a little bit of history on this. Back in August of 2010, Governor Quinn gave the Illinois Violence Prevention Authority and Director Barbara Shaw the framework for a new neighborhood recovery initiative. 5 days later, he committed $20 million to this initiative, and 2 months later, in October of 2010, the governor announced the neighborhood renewal initiative and increased the budget to $50 million. And to put this really in context, it wasn't until the next spring during the appropriations process that we found out that this had even gone on. Many of the legislators in Chicago didn't even know it had gone on. And from the very beginning, it raised some very legitimate concerns about the program. Why was it put in place? The RFP process, the procurement process, staffing. How do you measure success? Really didn't have any answers on that. We cut the budget that year for that program and come to find out in the appropriations process the next year in 2012 that the governor had, through his discretion, redirected money back into the program. So that year, we really took a look at it. We shifted the program into the Criminal Justice Initiative And we also introduced and passed House Resolution 1110, which directed the Auditor General to look into the Violence Protection Authority. So we're here today because of those findings. And let me state from the beginning, we were very, very concerned about how haphazardly and quickly this was put together. Different programs, different co-ops, different people putting things together to make it supposedly happen. And I think you'll see today in today's report that it wasn't put together right, that it was put together too fast, there was no oversight, and that it also raises the very strong suggestion that this program was initiated in funding just for campaign workers and to help with the re-election campaign that year. So with that, I'm going to turn it over to Senator Bivens.
Thank you. Hi, Tim Bivens, State Senator, 45th District. I was a county sheriff for 20 years. I spent 32 years in law enforcement. And quite frankly, if someone, an investigator, had brought this document to my desk and presented it to me, I would have called for a multi-agency task force to immediately start a criminal investigation. These funds that have been used, taxpayer dollars, there's no accountability. If you read the report, which I'm sure you will, you can see that 2 out of 23 sample providers had closed their doors. The funding that remained with those agencies never went back to Illinois Violence Prevention Authority. This is an ongoing pattern in this state. It's legalized theft, in my mind, of taxpayer dollars that go to programs. They take state and federal money and it goes to various programs that don't work, don't exist, close the doors, and nobody can figure out what happened to the money. So I believe that a criminal investigation should be started. You had money being spent for handing out flyers to go to wellness programs, to yoga programs, to field museums. You had people marching in a parade for the governor himself with tax dollars. There should be an investigation, ladies and gentlemen, and I trust that there will be. Thank you.
Good afternoon. I'm State Representative Dwight Kay from the 112th District, Glen Carbon, Illinois. In my days off from the Capitol, I actually run a very large corporation in the state of Illinois. And I would tell you that no corporation who wants to stay in business would spend money the way the governor has spent money with respect to the NRI. Put very, very bluntly, we have fleeced the taxpayers of Illinois with respect to the $50+ million that has gone to this initiative. Let me explain to you just exactly what's transpired here and what Representative Rice uncovered. 2 years ago in appropriations committees, we started asking questions about planning, accountability. Were people turning in time cards? Were people actually on the job, and what were they doing on the job? And the executive director of this particular initiative, this program, had no answers, not one. So what we have found today, and echoing what Senator Bivens just said, what we have found today is criminal activity. We find governor's initiative of $50 million going somewhere, but we don't know where, for something we don't know what, and we have no way to account now for funds expended. Let me just say this to you. It is no wonder that the state of Illinois is in the condition it is today, because quite frankly, when you give money away, as we have done here with no accountability, and move it in 2 months from a $20 million payout to a $50 million payout, you have to start asking questions, which we didn't do until 2 years ago. The bottom line is simply this. This is all politics. This has nothing to do about people and the betterment of the people of the state of Illinois. This is pure politics, and it's politics at its very worst. We have used taxpayer dollars in a wasteful manner, and as I said before, all we have done is fleeced the people of Illinois who work hard, pay taxes, and do the right thing.
Senator Matt Murphy from Palatine, and just to sort of follow up on what my colleagues have indicated so far. I mean, let's put this in the appropriate context. The governor is in a neighborhood in Chicago in mid-August 2010, looking at polls that have him down in the governor's race coming 2.5 months later by double digits. He's looking at a depressed base that isn't going to turn out, and he's going to lose this election. Now, you all down here know how quickly Illinois government moves. Molasses in July comes to mind. Government in Illinois can't get out of its own way, but they can find a way to come up with tens of millions of dollars from August to October. This program was set up October 6th. That's how quickly they got it moving when they wanted to get it moving. And they had tens of millions of dollars on the street by the November election. That, ladies and gentlemen, is taxpayer walking around money. And it's totally inappropriate, probably illegal. Pat Quinn fancies himself as a man of the people, a servant. We hear it in every address. But a governor who's really putting people first doesn't take tens of millions of their dollars for his own political slush fund, especially at a time when his government is hurting developmentally disabled and mentally ill in our state. Placing his own political career above the neediest among us isn't the act of a servant. It's just another example of the arrogant sense of entitlement that has steadily worsened throughout the Blagojevich-Quinn era of one-party rule in Springfield. The scandal, you want to know why people are so jaded in this state? Read this report. Read this. The scandal exposed in this report makes clear that Governor Quinn has broken the trust of even those who said, you know what, I don't always agree with him, but, you know, his heart's mostly in the right place. Was it here? Was it? Read the report. Can you honestly say that? This is another example of why it is well past time for us to get a new governor in this state. And I join Senator Bivens in calling on the appropriate authorities, starting with the Executive Inspector General, and then hopefully from there the U.S. Attorney's Office to investigate this, because this is disgraceful.
Any questions?
Question?
How will things be different under Governor Rauner? The news release says that the governor broke the law by shuffling funds in the second year. I think what was the law broken there? What did he do?
The finding was that discretionary funds were transferred from GRF to an appropriated violence prevention fund, and then a non-appropriated special projects. Basically, what he did was he created an off-budget slush fund that he interpreted to not require to be expended within a given fiscal year. He interpreted it as the appropriation authority continuing, and the attorney or the auditor general here has indicated that that was not the case.
Matt, is there anything here that rises to the level of an impeachable offense, do you think? I mean, you guys don't control that, obviously, the Democrats do, but...
Well, I do think it warrants exploration. I mean, we want to be proper or prudent about this. I mean, the appropriate course is to start with the Executive Inspector General. This is a damning and very thoroughly researched report right here. The Inspector General should take this and start to make assessments about whether or not that type of action is warranted. If this rises to the level of criminal conduct recognized by the U.S. Attorney, I don't know how you don't say it's impeachable. I mean, Governor Berkowitz was impeached. Some of the things he did were criminal, but some of the things he was impeached for were not. So this may very well rise to the level of being an impeachable offense.
Senator, you had a good laugh at my question, and I was only partially kidding. How prepared are the Republicans to run a clean government if even Pat Quinn can't run one?
Well, I'm not here to speak for any gubernatorial candidate in particular.
You said we got to
Absolutely.
get out there, and so now what?
Well, I don't recall an administration under Republican control that was as sloppy and as either of the two that the Democrats have thrown at Illinois ever since. Blagojevich-Quinn has been a disaster in every single way possible. Legally, from a policy standpoint, from an administrative standpoint, after 12 years of trying these guys, do I think we deserve a shot? Yeah, absolutely. And the reason is not for partisan politics, because I don't think the state can handle any more of these guys. Now, did Governor Edgar administer a better administration than these guys? Yeah. George Ryan went to prison. He went to prison for things he did when he was the Secretary of State. I don't recall people saying that he mismanaged the governor's office to the extent that these guys have. Jim Thompson, I think most people look fondly upon that era as a time when the state government was actually rather well managed. I can't think of anybody who would second the motion that Illinois government has been well run under the two Democrat governors who have had it for the last 11 years.
So what crimes were committed here and who committed them?
Well, I think that's going to be part of the investigation going forward. I mean, this is the tip of the iceberg, this Auditor General report.
Senator Bivens, you said it's indictable, what you read here. What do you
I think what I'm saying, this is the kind of information that indictments are made out of. Obviously, there has to be an investigation. Everyone's innocent until proven guilty. But there's also a thing called probable cause. There's more than enough probable cause here. When you use tax dollars to have people march in a parade for you campaigning, I don't think that's not only appropriate, may very well be illegal. So I think there's more than enough probable cause as you read this report for an investigation to occur, and the determination upon that investigation will determine whether or not charges are filed.
you have details on that parade?
There is video of that parade. It's been reported. So the information's out there, has been out there for quite some time.
The parade and the yoga and the flyers, that's part of the media report, it's not in this report.
Correct. That's correct.
How does it happen, whoever wants to answer that the state can spend $50 million without any oversight? What about checks and balances?
Well, the governor has the ability to move 3% of agency money around for emergency purposes. And, there's...
Did he authorize this as an emergency?
Well, I don't know if it was an emergency. He might say it was because of so-called crime in the streets. I think you have to look at the crime then and the crime now. It didn't do a darn thing. But yes, the governor has the ability to move that money around. And, 3% of the budget isn't a lot, but more than what this here amount was. And I don't want to get away from the context of this report with criminal stuff and things, but I mean there are some very damaging things here. I mean these are Berkowitz actions that hopefully we learned our lesson from. Implemented a new program, no documentation to show how it was working. Did not do due diligence, the RFP process, timesheets were not constantly maintained. I mean, these are just basic things that we should have learned from the last administration that clearly weren't being done. And I also want to point out that the second year that we started really questioning Barbara Shaw on this, they filled C1 so full that the fire marshal came in. I mean, she was advocating, we got to keep this program, we got to increase the funding back to the way it was before. So not only were they doing this stuff beforehand, but they were coming back advocating for it to be done again. And that's a pretty disturbing pattern.
I can't imagine that the outrage is one-sided, though. I wonder if any Democrats would join you in decrying what's going on and embracing the results of Mr. Holland's report.
Well, the Speaker obviously allowed my resolution to go forward. He was in on many of the talks. If you remember back in 2012, we had a very hard time passing the budget that year. He okayed the resolution going forward. I think it passed 107-1. There were a lot of minority representatives that were very upset that they weren't given a chance to bid on these programs and the programs weren't being implemented in their districts. So there was very much bipartisan effort in the audit.
Hey, what about here today? Did any of you ask any Democratic members of the legislature to join with you in condemning the way that state appropriations were being spent?
I don't know the answer to that. I mean, it's going around the Capitol pretty heavy, so they all know about it. So.
How about the next step? Do we go to the Attorney General and ask her, or do you go outside and ask someone like the FBI to investigate?
I'll let a lawyer answer that.
Yeah.
Matt?
Well, the part of the issue is the Attorney General was in the oversight board of the Illinois Violence Prevention Authority when all of this occurred. So the reality of the situation is that's an inherent conflict for the Attorney General. That's why we are suggesting that we start with the Executive Inspector General, and that if there is an appropriate basis based on their finding, which if it's anything like this finding, I don't know how there wouldn't be, that it go from there to the local FBI office or the U.S. Attorney's office.
On a scale of severity, because a lot of people will automatically hear this and see a bunch of Republicans against a Democratic governor, that this is just pure politics.
Well, it's not our report. It's not our report. It's the Auditor General's report, and the Auditor General, is a Democrat. So this is no partisan witch hunt. Every once in a while, the truth comes out of this town, and I just hope people have the courage to look at it and assess what it shows.
Will you ask the Inspector General? There has to be a request from the Inspector General. Who's going to do that?
Yeah, there will be a request.
One other thing I wanted to point out in this report that I don't think we mentioned, because this was supposed to be for violence prevention. 7 of the top 20 Chicago communities for violent crime totals did not receive these funds. 7 of them didn't receive any funds. Aldermen were able to say where the funds go. It's all in this report. Again, this is and to answer your question about the partisan nature of this, when I was county sheriff, I called for George Ryan to step down publicly. So I view this from a different lens, perhaps, than others. I don't care who is in office, what title or name they carry, whether it's Republican or Democrat. I do care about good functioning government, and this is a repetitive behavior that continues. We've seen it with the Save a Life Foundation. We've seen it with other organizations. This getting of state and federal grants and then filtering out, and then we can't account for it anymore. You saw the FBI sting where several people were arrested in that for these $25,000 grants. This is a pattern of behavior that's going on, and it continues to go on, and I think this report points that out. Thank you.
Is that also, though, an indictment not just of individuals, but of the way the state is structured, and that there's not enough internal controls on spending or maybe legislative follow-up as far as government oversight to control this kind of thing?
I think, personally, I think there's plenty of controls in place, but not being utilized. I think people turn their heads, and when you have complete dominance by one party, and whether it's either party, you can control everything. And when you do that, you can turn a blind eye into these things, and we pointed this out in the Senate floor last year. I spoke on this, Senator Murphy spoke on this, others spoke on this Neighborhood Recovery Initiative. It fell on deaf ears. We still went forward with more money as being proposed again, more money for these programs. And it's the new way. State and federal grants, you don't have to go out and run numbers or sell drugs. You just get these grants and you can filter them out wherever you want to.
Of the $54 million, if I have the number right, is any of that yet to be recovered, or is it all been spent?
50. Go ahead. Good.
Give me a second, Terry. I got it highlighted on the side. I believe it's somewhere around $2 million has yet to be accounted for because of the either unspent, the timesheets and the amount of staff don't match the money they were given, or they folded up and never returned the money. And you mentioned legislative oversight. This was never voted on by the General Assembly. This was implemented by the governor and funded by the governor, and we didn't find out about it until 6 months later. So this was never a program that was, debated and talked about in the General Assembly, nor the oversight.
So this goes back to my earlier question. Maybe you already answered it. How does the governor? Is it because the governor can move 3% of funds, or is he given a pocket of is he given a slush fund within the budget that he can spend it the way he wants? Because I think citizens will hear this and go, "How does that happen? That a governor can spend $50-something million without the legislature having approved it?" As I recall, Governor Berkowitz was vetoed for spending money without authorization.
It's the ability to move money around. 3% of each agency can be moved around for so-called emergency purposes. And, it drives the people on the Appropriations Committee kind of crazy on both sides of the aisle that they have that power. Now, there are probably legitimate reasons why they may want to do that, natural disaster or something like that. But
Are any of you looking to offer a bill that would limit the governor's ability to move money around unless there was a recognizable state emergency, that he would have to have affirmed by the legislature?
You know, I can't speak for everybody up here. I can't speak for everybody in this building. But you know, when does it come to an end that we have to legislate morality and ethical behavior? I mean, you know, we might have a perfectly good governor 5 or 10 years from now that needs that ability. It seems like we always go back and try to fix some problem that someone did that they were probably taught in grade school not to do. You know, when do we stop doing that?
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.
Next, we speak with State Representative Tom Cross about his race for the Republican nomination for state treasurer. This runs about 5 minutes.
State Representative Tom Cross, thanks for joining us again on the Illinois Channel. And last year at this time you were the leader. Right. Now you're a candidate for state treasurer. Just give us an overview. How's your campaign going?
It's going great. I actually am one of those guys that enjoys traveling around the state. It's a great state, great people. You know, we have a lot of good things going for us. Some of the best agricultural land in the world, great hospitals, universities. I even say every now and then we have good ball teams. It depends where you live. But we're struggling, and people are frustrated and angry. And we're talking about trying to do things a little non-traditional way of being an aggressive treasurer, an activist treasurer, and people are responding to that, and it's going well.
As you are in this legislative session this spring, you're not the leader. How's it feel a little different for you, or how's your time being spent differently?
Well, I enjoyed being the leader. We had a great caucus. Unfortunately, we were always kind of struggling with the Democrat majority and tried to make our case, and at times did, sometimes we did, and that's the legislative process. But we have a good leader in Jim Durkin, and we have continue to have, I think, a good caucus. So it's in some ways it's a little liberating because you don't have the role of the leader. But I love this caucus, the House Republican Caucus, and this institution is good, and it's had a lot of history. Again, we're just kind of going through some real struggles right now as a state, and we're all trying to figure out how we can best fix those.
You have an opponent for the Republican primary. One of the issues for state treasurer that was brought up is that you're not like a CPA background. What would you say? I presume you would say your experience here in the State House, your years in the legislature, gives you some institutional knowledge, and having been the leader, you have your fingers on the pulse of what's happening around the state. I would guess. I'm not trying to make your case for you, but lay out what's your response as far as you not having the auditing background that a CPA might have as far as your qualifications.
Well, the one thing about that argument that he makes is we have an Auditor General, Bill Holland, who I happen to think does a very, very good job. And there's a distinction between a treasurer who this job is to invest money and also keep an eye on Bright Start and also the iCash program. So very distinct responsibilities between auditing and investing. But look, my goal here, and the reason I'm running, is this state's a mess. And I think the treasurer ought to be actively engaged in trying to turn this state around. One of the things we believe as treasurers that we ought to have an honestly balanced budget. This Constitution of ours, the state of Illinois, says you should have a balanced budget. We haven't seen a balanced budget in 10 years. I've seen the games that get played, the gimmicks, the manipulation of numbers, and we have a responsibility as treasurer, I believe, if I'm elected, to enforce that Constitution. And we're going to be very, very aggressive about that. You have got to balance this budget today and going forward. If you're going to have any type of turnaround in this state, you've got to do some other things. But balancing the budget, we have $8 billion of unpaid bills. We spent $300 million last year in late fees and penalties. And small businesses can't survive if they're vendors for the state when we don't pay them. So it's critical we turn it around. And so knowing what goes on and how we got here can help us get out of this mess, if you're willing to be aggressive about it. My opponents don't believe you should enforce the Constitution, have said I disagree with that. But I think it's a novel way to do it. It's a bold way to do it. And we're going to take that. We have to be bold to solve these problems.
I know you have to go to the House floor here in just a minute, but as just earlier today here in the Capitol, the House Revenue Committee said that they agreed to a revenue projection of just under $34.5 billion as far as GRF for the 2015 budget year. One of the issues that they're contending with, as you know, is that the state income tax is going to go off halfway through this fiscal year. What is your position, both as a candidate as far as that tax increase, and what do you hear as you go around? You must hear from constituents or people who would ask you and their thoughts on that tax increase.
I think most people in the state want it to go away, and they were promised that by the Democrats when they passed it. They said, we're going to do this to pay off bills, and they continue to spend money time and time again, year in and year out, that exceeds what we have. And so this state has got to learn to live within its means and make sure that we don't spend more than we take in. Could be 34, could be 36, could be 30. We've seen the Democrats spend more and more and more, and that's got to stop.
Are you for the keeping the tax increase or taking it off?
Oh, it needs to expire.
What about I'll just ask you, I think I know the answer, but as far as changing the state from a flat tax to a progressive tax?
Oh, I think that's a huge mistake, and the people advocating that are pushing for wanting more and more and more money, and again, that's the wrong way to go. People are struggling in this state right now, and we got to give them some relief.
All right, Representative Tom Cross, I hear the bells ringing.
Right, see you.
You're watching the Illinois Channel.
Next, from the state capitol, we talk with Kim Meisch of the NFIB of Illinois as she talks about the impact a rise in the minimum wage would have on small businesses. This runs about 10 minutes.
Kim Meisch with the NFIB, thanks for joining us on the Illinois Channel. And as we are here in February at the state capitol, the state budget has been pushed aside until after the primary in later March. Well, you're here and you're talking to lawmakers. What are some of the issues that are of concern to small business owners?
Sure. Well, it's been an active season so far, given that we've only been in session a few weeks. But there are a couple of issues that we're lobbying. Number one, of course, is the minimum wage increase. There's proposals out there to raise Illinois' minimum wage to $10.65 over the next 3 years. My membership, small business owners across the state of Illinois, are adamantly opposed to that. Illinois continues to be one of the highest states for unemployment. I think we're ranking third highest in the country. We're also one of the highest costs of doing business states. It's expensive to be a business owner in the state of Illinois, and to raise our wage to $10.65 would make it even harder.
What specifically kind of feedback have you had any specific feedback from business owners who would say how that would impact their operations?
Sure. Well, most small business owners have said there are only so many dollars to use for labor costs. Of course, they have money they have to spend on capital projects, for product, for transportation. And so when government steps in and artificially sets a wage rate, something has to give. And so most small business owners will look at decreasing hours worked, maybe working a little more themselves, closing their doors, which of course is the worst option. And in some cases, particularly in border communities, they can move across the border. Illinois has a minimum wage right now of $8.25. We're an entire dollar higher than most of our surrounding states. So it really is a competition issue.
And what do you say to people like the governor who would make the case, well, it's hard to get by on minimum wage?
I would say that the minimum wage was never meant to raise a family of four or raise a family at all. A minimum wage is the bottom wage that many high schoolers and colleges, in fact, the vast majority of people making minimum wage are high school kids and college kids. That first job where they learn how to show up on time and have good manners and dress appropriately. We would argue that perhaps Governor Quinn's time would be better spent making Illinois a better place to do business so that we can draw manufacturing jobs and other types of industries back to the state of Illinois and make us a better state to do business in, and hopefully with that would bring higher paying jobs.
Any other issues as we are early in the process but that are bubbling up of concern to small businessmen?
Sure. We have another issue that we're working which would mandate employers with more than 10 employees to set up automatic IRA accounts for all their workers, both part-time and full-time. We have a problem with that, first of all, because the state of Illinois would administer that retirement program, and the state doesn't have a very good track record when it comes to handling pension dollars, or for that matter, college saving dollars. And so that's an issue that our members are adamantly opposed to, and our ballot on that question, 95% of our members said they were opposed. If a business owner, or for that matter, an individual wants to set up a retirement account, there are many, many opportunities for them in the private sector to do so. We just don't think government should get involved.
Not as a mandate, you're saying?
Correct.
Do you know, how many businesses actually have some kind of a voluntary retirement system when they set up, or have you not polled your?
We have not. I think the statistics say that about 40% of businesses do not currently have a retirement option for their workers. And to that we would say, let's work with the state should be working with the private sector, the financial advisors, the small business owners, to educate folks on the fact that setting up retirement accounts do make sense. It does make sense in terms of saving for their future. But we just, again, don't think government should step in and start mandating employers to do this. Or perhaps the state should do a study like the state of California is doing right now. Let's find out what we can do to help facilitate small business owners and their employees in terms of retirement.
And let me use that as a transition point. We have talked just now about two things that you don't want to have happen. Is there anything you're pushing for that would increase employment in the state, or at least make it easier to do business?
Sure. Well, of course, Speaker Madigan came out talking about reducing the corporate income tax in Illinois. We certainly favor that, but we also said to the Speaker, don't forget about small business owners. Small business owners, the vast majority, something like 75%, actually pay the personal income tax. They don't pay the corporate income tax because of how they're structured. So we would certainly urge lawmakers to take a look at that, because of course, as we reduce taxes, the idea that there will be more economic activity and opportunity in Illinois certainly would bode well for creating jobs. We also are looking to legislators and the governor to reduce some regulations. We've got to get government off the back of small business owners if we want them to create jobs.
How much of an issue is it, speaking of regulation, that every time there's some regulation, as a small business owner, you have to comply with the regulation? Right. There's paperwork. To what extent is that administrative burden an issue with your members?
It's huge, because my members don't have an entire floor filled with lawyers or HR experts. Most small business owners many times are doing their own payroll. They're certainly trying to figure out how to comply with all the rules and the laws and the regulations in the state. So it is difficult. And so we, as both at the state and federal level, we continue to see the agencies acting on their own or by executive order, sort of piling on when it comes to telling business owners how to do things. And while we certainly understand certain regulations for safety are certainly important, some of this stuff is just becoming too extreme and making it difficult for small business owners to comply. And of course, if they don't comply, they don't get told how to remedy it. They get hit with a fine or a penalty, and that's money out of their pockets and money they can't use to hire people.
Let's just talk, for those who don't know, what is NFIB and how many members are there in the state of Illinois?
Sure. The NFIB, we're the largest small business advocacy organization in the state of Illinois. We have about 11,000 members in Illinois, but we're also a national organization. We represent about 350,000 small business owners across America. We lobby in every state capital and in Washington, D.C.
And you're nonpartisan, I guess. You have members that support you on both sides of the aisles and probably those who oppose you on both sides.
Correct. We like to say we support those who support us. And so we do a voting record every 2 years, and our members know, where they're elected officials, how they're voting on issues of importance to them.
Just before we let you go, as we go into this election year, Illinois has been struggling for years with its economy. What kind of an environment is it right now for small business, and has it improved over the last 5 years at all, or is it getting worse? How would you assess the current environment for small business in Illinois?
I think it's improved a tiny bit, but really there was only one place to go, and that was up after the Great Recession. I think that what's probably concerning are groups like Moody's Analytics last year said that Illinois is one of the few states that is very close to falling back into a recession, depending on what goes on in the state capitol and what the governor does. And so that's why it's troubling when we have Governor Quinn talking about a minimum wage increase and a paid sick leave mandate. These types of things that just add to the burden for small business owners, because small business owners are the top job creator, not only in the state of Illinois, but in the country. We need to be looking at ways to make it easier to do business, easier to succeed in the state if we're ever going to climb out of this hole.
And just one last thing, when we say small business, some people might think that's a mom and pop, and that would be small business. How large is a where do we move from being a small business to a larger business? What's your kind of definition of small business?
Well, I will tell you that the SBA, the Small Business Administration in Washington, characterizes a small business as fewer than 500 employees. We don't agree with that necessarily. We often use the rule of thumb of 50 or fewer employees is really the small business, primarily because 50 seems to be a magic number when it comes to federal and state law. Oftentimes that's a threshold that triggers more mandates. For instance, the Family Medical Leave Act gets triggered if you have more than 50 employees. So we say if you're under 50, you're considered a small business.
And so probably if any of us look at what we do, whether we buy gasoline or go to the dry cleaners or any number of the butcher things that we would do to provide products and services for ourselves, we're probably using a lot of your members as
we hope so.
supplying goods and services to us.
Absolutely. Absolutely.
All right, well, thank you again for joining us.
Okay, thank you so much.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.
Next, from the state capitol, we talk with a representative of the American Lung Association of Illinois. We hear about proposed legislation that would prohibit smoking outside on college campuses, as well as other proposed restrictions. This runs about 10 minutes.
Kathy Dre with the American Lung Association, thanks for joining us on the Illinois Channel. Tell us, what are some of the issues that you are advocating for this year in the Illinois State Legislature?
Our number one priority is Senate Bill 2202. It's smoke-free college campuses. Last year it passed the Senate. It got over to the House too late. So we just passed out of House Higher Education Committee last week, and we're working the entire House now.
And because this is the same legislature, you don't have to go back to the Senate. You can just bring it over to the House, and then once that passed, it would go on to the governor?
Actually, we do have to go back to the Senate because we had to put in an amendment to change the dates. The effective dates.
What would the bill do?
It would make all college campus property smoke-free.
And that would include whether it's a community college or four-year college or anything like that?
Right, all publics.
Now, I just saw a report that down in Southern Illinois University, I don't know if I guess they're doing this on their own, that they allowed people to be smoking out in the parking lot, I think. Would your bill preclude even that?
Yes, parking lots would be smoke-free.
What would you say to those who say, we're trying to give up smoking, but in the meantime, to feed our habit or something, at least we're outside, we're not hurting others?
This is just an extension of the bill that passed in 1994 to make all secondary and elementary schools, public schools in Illinois, smoke-free. And actually, at that time, teachers smoked inside in the teachers' lounges, and so that was a big deal back in 1994. The students are already used to smoke-free campuses when they move to college, and we just think it's the right thing to do. That particular age group, 18 to 25, has the highest smoking prevalence rate of any age group.
And where do we stand right now, just in general? Let's go back and do a little bit of an overview. Where can people smoke currently, not irrespective of college campuses, just in general? Is it anywhere outside?
You can't smoke within 15 feet of any public building.
And public meaning any place like a bar, or do you mean like a state-owned?
Any kind of a bar, restaurant, any kind of a workplace, or a government building.
Are we seeing any... and maybe it's too early to tell, are we seeing any health advantages thus far from the prohibitions against smoking inside that Illinois has passed, I forgot how many years ago it was now, but is there any evidence that we're gaining as far as health results?
It is too early for many aspects, but we have had reports that there are fewer heart attacks in the emergency rooms in Illinois.
And what year was it that Illinois prohibited smoking indoors?
It took effect January 1, 2008, so it's been 6 years.
6 years, all right. I know a lot of the bars at that time said it would really hurt them. Has there been any follow-up studies to see to what extent it has impacted any businesses one way or the other?
We did several impact studies within the first 2 or 3 years. I know within 3 years, there were actually more bars that were open in Illinois than there were before Smoke Free Illinois passed, and revenue had also gone up. So,
Now, one of the other issues, and it's, we think, of course, you as smoking, and there's a number of lung-related issues that I guess you would become involved in. One is radon and the testing. To what extent are you involved in that, and where do we just stand? And give us a general overview.
2 years ago, we passed 2 radon bills. One would require all new homes built in Illinois to have a passive radon system built in when the house was being built. That was Representative Emily McCasey's bill. And the other one required all daycares to test for radon, and they would only have to do it once every 3 years when they renewed their license.
And just for those who've forgotten, what is radon and how bad is it for us?
Radon is a colorless, odorless gas that is in all buildings that we have. Some states are worse than others. Iowa has a very high concentration of radon. Illinois, in certain areas, has a very high concentration of radon. You don't know if you have radon in your home or in your workplace unless you test, though. It is colorless and odorless.
And what impact does it have on people?
It causes lung cancer.
And I'm kind of curious, we're standing here in this basement of the state capitol. Has the state capitol ever been tested? Do we know if there's radon gas here?
I don't know.
Be something to find out. Are there any other issues aside from the cigarette smoking on campuses that you're following right now?
We're also working a bill to prohibit smoking in cars with minors, and that is being heard in Senate Public Health Committee.
And minors, so anyone under the age of 18, or are we doing 10 and below?
Anyone under the age of 18.
And again, what would you say about those who say, we're not hurting anyone else, this is our own family, and at what point does government stop its intrusiveness? How do you respond to that?
The American Lung Association has always advocated for those who don't have a voice here. When we worked on Smoke-Free Illinois, we worked to protect workers. People in the workplace who didn't have a voice. In this instance, we're working to protect children. Vehicles are a small, confined space. You could have 1 or 2 or even more smokers in a car with a child, and it can cause SIDS, sudden infant death syndrome. It can cause upper and lower respiratory problems, bronchitis, pneumonia, middle ear infections, and middle ear infections are the cause of the most childhood surgeries. Also, future problems with cancer or heart disease. So there's lots of things to consider. And over the years, I've received many calls from people who are concerned about maybe grandma taking their children in the car and smoking, or maybe a divorced parent, or I've heard all the different scenarios. And what can I do? And if it's not a law, there's really not much that they can do to prevent it from happening.
One last question. I would say asthma is something that there was apparently a large increase in asthma cases over the last 10 to 15 years. Do we know what has accounted for that? Was it just better testing? Is it something that was actually affirmatively causing more asthma, or are we still lost on that?
I think that we don't know the answer to that. I do think part of it is testing, and I think that the medications that are available now, we've seen a lot of people be able to keep their asthma under control better than they were able to in the past.
And as far as the American Lung Association, if people want to get more information, I guess they can go to your website for whatever of these issues or others that they might be interested in following?
Right, lungil.org. You can also, of course, I always have to put in a plug for the Illinois Tobacco Quit line, which is at our office, and that number is 866-QUIT-YES. And last year we answered 85,000 calls at our office to help people quit smoking in Illinois.
Some of the things what kind of things would you tell them that could help?
The counselors, people always think that they can't quit. They've always, they've tried everything. And that's who these counselors deal with. They work with people who have tried everything. They will talk to you about what you have tried and what worked maybe for a while. And, they will try to find something that will help you. And every time you call, even if you don't get the same counselor, Each counselor keeps nurses' notes, and so you don't have to start your story over from the beginning every time. And there's no limit on the number of times that you can call, and there's no time limit. In many states, there are time limits, and you can only call once, or you can only call 3 times, or whatever. But not in Illinois. There's no limit.
This is an unfair question, and I shouldn't throw it, but maybe you know off the top of your head, maybe you don't. If we look back over 50 years or so, over some prolonged period of time, do we know, how have the rate of smoking as a general population? I'm going to guess it has gone down, but do you actually know any kind of numbers off the top of your head?
Sure. Actually, in January, we just celebrated the 50th anniversary of the first Surgeon General's report that came out in 1964. And at that time, in 1964, about 40% of the population smoked. And now, nationwide, it's about 18%.
That's quite a drop.
It is. But it's not enough. We still have work to do.
All right, Kathy Dre, thanks for joining us.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.
Next from Chicago, our contributing correspondent Jeff Berkowitz sits down with the National Review's Ramesh Ponuru. The two discuss the upcoming 2014 midterm elections and the potential GOP candidates for president in 2016. This runs about 30 minutes.
Who would you say is the leader of the Republican Party now? Is it the Speaker of the House, Mr. Boehner? Is it somebody in the Senate? I guess not, because they're in the minority. Is it Mitt Romney because he ran for president? Probably not. Who is it?
A party that does not have the White House, it doesn't have a leader. And I think that is the case with the Republicans now. And I think until a nominee emerges, until somebody has locked up the nomination sometime in the spring of 2016. Obviously, this is something that comes with ups and downs, the fact that you don't have a leader. But it's, I think, inevitable, and it's just something that we have to deal with and work with.
So should there be an alternative to Obamacare that comes from the Republican Party? And if so, who nominally should be offering that? Should it be the Speaker of the House?
I think it is less important that the Republicans unify behind an alternative proposal, although I think it would be good if they did, behind a good alternative proposal, then that almost all of the Republicans have an alternative. They don't all have to have the same alternative, but I do think that there has to be a way of credibly saying that Republicans have solutions that would get coverage to millions of people without the costs, without the coercions, without the threat to medical innovation that Obamacare poses.
So which Republican, or is there a Republican out there now that has an alternative that you would think would be a good alternative to Obamacare?
Well, I don't think that any of these alternatives are quite where they need to be, but I think there's been some progress in the right direction. And there's also, there are some Republicans who have advanced credible plans. I think Paul Ryan, he didn't get the entire House Republican Conference on board, but he does have his own plan. John McCain has had his plan. Tom Coburn has in the past offered plans. Richard Burr, senator from North Carolina. So there are a number of isolated Republicans, some of them quite influential, who have had plans. And again, I have my concerns about all of these plans, but I think that there's been some positive movement. If you look, for example, at the Republican Study Committee, the 175 conservative House Republicans, they recently came out with their own plan, which I think is, again, a step in the right direction.
So which of these various plans, you said it's important that many Republicans have plans. They don't have to unify behind one. But if you had to give one of the ones you referred to, which one do you think would be closest to the one that would be best in terms of policy and two, most saleable politically?
Right. Well, I don't think that they're there yet. I think.
Is there anybody though is there any plan out there that you could talk about, or should I ask maybe Ramesh? Do you have a plan that you want to talk about?
Well, let me put it this way: the Paul Ryan plan, which is also the John McCain plan, I think has a lot of great features. And the most important of these is it changes the way health insurance is treated by the tax code. So right now, there's an open-ended tax break for employer-provided coverage. And the tax break is more valuable the more expensive your coverage is. So there's no incentive to economize. And what Paul would do is flatten that into a tax credit. So you get this credit regardless of how much your health insurance costs. If you choose a more expensive option, you pay that difference. If you choose a less expensive health insurance option, you pocket that difference. Where I think that Congressman Ryan goes wrong is that he is a little too disruptive to current health insurance arrangements, that he wants a sort of big bang movement to a new, freer market that I don't think the public would really bear. So I would like a more gradualistic approach.
Well, one of the main problems that I think people referred to before Obamacare, when they said what's wrong with the healthcare system, was the problem of pre-existing conditions. And as most would know, that's simply when somebody wants to buy insurance, but they have a pre-existing condition. Obviously, the insurance company can't insure you for that because you already have it. And they could have been very responsible. They could have, from the time they were 18, bought insurance. They may have suffered a heart attack, cancer. While they were on a group employer or employee plan, they could not be terminated. But if they left their job and then sought to find an insurance policy, now having that pre-existing condition, they couldn't find one. Or if they could, it would have been prohibitively expensive. I think most would agree. Have I said anything that you would disagree with? And if so, if you don't disagree, what would be your proposal to deal with pre-existing conditions?
Right. Well, first of all, recognize that the problem, which is a real one for a discrete segment of the population, is the result of the kinds of government policies we've had that have distorted health insurance markets. In a functioning market that where you didn't have the kind of heavy federal encouragement of employer-provided insurance, it would be much easier for individuals to own their own insurance policies, and in a situation where you had a national market in individual insurance policies that wasn't as stunted and misshapen as our current one, thanks to federal law, it would be easier for people to get renewable policies.
So, but what do you...
renewable catastrophic policies. Okay. So, you move to this new system where you are allowing a market,
the tax credit system you're talking about.
Yeah. Renewable catastrophic policies to be sold. Now, there's still the people who we already have, who the current system has failed, and they're now essentially uninsurable because they're already sick. You can't insure them against the risk of getting sick because they're already there. So I think the thing to do is you don't pretend that you're going to insure them. You give them money to help pay for their medical costs. And what that means is you have subsidized high-risk pools. And you design them so that they offer that help. They don't create an incentive for people not to get private insurance coverage. And over time, you'd expect that that subsidy would decline because you're allowing this new market to develop where people don't find themselves falling into this problem in the first place.
And you would say it's less distorting than the current Obamacare system. I suppose you would say this, because currently what Obama does, or his Obamacare does, is take care somewhat of the pre-existing condition by lowering the cost tremendously for people with pre-existing conditions, but essentially taxing other people who don't have such conditions, so it raises the cost of their insurance, but it does so selectively, as opposed to if you had a general tax, all of America, or all of America without pre-existing conditions, would be paying for, I think, under your system.
Yeah, there's no good reason, I think, to hide these subsidies and funnel them through the larger insurance system. There's no good reason for taking this admittedly real, significant problem for a discrete and relatively small group of Americans and reworking the entire insurance market in order to work around that problem. And that's what I think Obama
It seemed to me, maybe I've got it wrong, tell me if you disagree, that the main motivation, I guess, for people, not necessarily for the president, but for people who thought something had to be done about the healthcare system in the last 4, 8, 12 years, pick it, it was that, one, we had a pre-existing problem, and people think we're sympathetic to that, especially people who had pre-existing conditions, but they had a neighbor, they had a relative, they had a friend, and it did seem very unfair. You know, if you happen to, you sort of lose the lottery. You have a child born with a severe chronic condition, that's a pre-existing condition. You develop one. So that was one problem. that to handle. The second was there are a lot of low-income people who I think people legitimately felt they would like to assist those folks. People are trying, they're working, they're not able to cover all their costs. So perhaps a subsidy of some type. I would guess pre-existing conditions might be less than 5% of the population. Low-income individuals I've described maybe 20% of the population. So did we adopt a major program of revamping the whole healthcare system to address a problem that probably 25% of the public incurred? Or am I wrong on that? Is it much broader?
I think that you're on the right track. I think it's not even so much low-income people who already qualify for Medicaid, but if you're above that income threshold, but you don't have an employer plan, you might still have a problem. So the two things that I think really motivate, your average person who supports Obamacare or who at least thinks it has some good features to it, there. The problem of people with pre-existing conditions who can't get insurance, and then just the larger problem of people who don't have insurance because they don't have access to a company plan.
All right, we're going to shift. Maybe we'll come back to healthcare, but I want to take advantage of. I should say you're usually not here. We're taping the show at the University of Chicago. It's your last seminar, last day as an Institute of Politics fellow, right?
Correct.
So where are you usually?
I'm based in Washington D.C.
Okay, so. And you were a senior editor of the National Review, is that right?
That's right, and I work out of the American Enterprise Institute, where I'm a visiting fellow.
All right. So you know public policy, you know politics, you keep very aware of this. Looking ahead to 2016, who are the realistic presidential candidates for the Republican Party?
Well, depends on what you mean by realistic. If you mean people who could make runs and win some primaries, that's a different question than people who could ultimately actually win the nomination.
Right, the latter. We're not going to fool around
right.
here. We're going to go for the people who actually could be, in your view, could win the nomination, and people who probably you would favor as a Republican candidate.
Right. Well, I think the people with the best shot at the nomination right now are New Jersey Governor Chris Christie, Wisconsin Governor Scott Walker, former Florida Governor Jeb Bush, and I think much lower in likelihood, Senator Marco Rubio from Florida.
And you would exclude Cruz, Senator Ted Cruz, at this moment?
Well, I should put everything I say about Senator Cruz by noting that he's an old friend of mine. I don't think that he is the likely nominee, although I think he could do very well in a lot of primaries, simply because, as far as I can tell, he would be running on a strategy of trying to consolidate the rightward third of the Republican primary electorate and then build outward. And although I think Ted is a very talented person, I've not seen that sort of strategy work in any of the primary races from 88 onward.
All right, so of the four you mentioned Rubio, you mentioned Jeb Bush, you mentioned Chris Christie and Scott Walker. Of those four, if you had a bet right now, who would you bet on?
I would bet on Chris Christie.
Okay.
I think Chris Christie has had a better 2013 than Mitt Romney had a 2009 or than John McCain had a 2005. I think he's really consolidated his position as the establishment favorite.
Now, some say, and certainly some of the more conservative folks in the Republican Party, he's simply too moderate. What do you think?
Well, Chris Christie is well to my left. But let's think about who the actual winners of Republican nominations have been in the past. Chris Christie has nothing in his record comparable to Mitt Romney's past support of abortion or his health care plan in Massachusetts that included an individual mandate. He has nothing comparable to John McCain's leading role with comprehensive immigration reform, his opposition to the Bush tax cut, his advocacy of cap and trade, and one could go on and on. It seems to me that the list of problems for Chris Christie with the right are significantly smaller in both number and importance than the problems with those previous nominees. And obviously those problems didn't keep those previous politicians from winning the nomination.
What's the most important problem that he faces from the right? What do you think the right thinks is the most important problem that Chris Christie has?
At the moment, I would say the thing I hear the most about is, I hear anything specific as opposed to just this general impression that he's too moderate, is the embrace of President Obama during Hurricane Sandy in the last days of the 2012 presidential election.
Was it also his fervor with which he advocated for the state of New Jersey, as if there's some kind of God-given right that if a state has a disaster, has a problem, everybody else should pay for it? Doesn't that go against the whole conservative grain? I mean, maybe the state of New Jersey and states that are, and they are somewhat hurricane-prone or disaster-prone, maybe they should buy some disaster insurance. Should they all look just to everybody else?
I think that
everybody else in the country should pay for their
I think
their
that,
risk.
You can make an interesting theoretical argument for that position, but the accepted practice has for many years been that when a disaster strikes a particular area, the federal government.
So Christie's well within the realm of reasonableness.
I find it hard to believe people would withhold the nomination for him.
It was that picture of him hugging or overly embracing Obama. He could have been gracious and accepting. Hey, did he go too far? I guess that's the criticism of him. Especially when Obama was looking for some sign of moderation, reasonableness. I'm sure that helped Obama in the presidential election, right?
Well, one wonders whether it helped him all that much, but it didn't hurt. And look, he went a little further than I would go, but at the end of the day, are people really going to not just be against him for having been an effective advocate for his state, but hold it so much against him that if he looks like he could be a winner, that they're going to say no? I have a hard time believing that.
So who's the second runner-up between Walker, Rubio, and Jeb Bush, in your view?
I would say, and maybe I'd give him the edge just because I'm more confident that he's actually going to run than I am with either of the other two. I would say Governor Walker.
And why is it? What makes you so confident he will run?
I just think in the case of Rubio and Bush, they can't both run at the same time. I think their political profiles are too similar. Their backers are too similar.
Florida
Republicans.
Although isn't Marco Rubio is somewhat a little bit more conservative? Don't people, one, suspect that Bush is a little bit more moderate than they might like if you're conservative? And two, the Bush name may be a big drag. Rubio doesn't have either of those, does he?
He doesn't, but Rubio has his own drawbacks that it's hard to balance against. For example, Bush has had a position of executive experience, which Republicans usually value, and which the general electorate seems to value as well. And Senator Rubio hasn't.
Now, is Walker too inexperienced? I mean, he's only recently on the national stage, and he's, of course, the governor of Wisconsin, who I think the image would be, and you could tell me if I'm right or wrong, as substance. I think the image was he stood up to the unions and collective bargaining, the public sector unions. He stood up, and it seemed to succeed. Is that the main thing that's going on for Scott Walker?
I would say it's not only seemed to succeed, but it succeeded. And it succeeded both at the substantive level and at the political, where the Democrats, their base really wants to repeal his reforms, but the public doesn't, and the Democrats are having to straddle a little bit as a result. That is an indicator of the success of Governor Walker's reforms. He's going to have to develop a profile on national issues. He's going to have to show mastery of those issues. But what he's done so far has been impressive. That is, running a very blue state that last went for Republican presidential candidate in 1984 and successfully governing it. If he can win re-election...
When is that re-election?
The re-election is in the fall of 2014.
Okay.
It's easy to
lose track of that. Is there any doubt? Have you kept track of that? Do you know if he's got opposition?
I would say he is... I'd give him the edge over Mary Burke, I believe her last name is, who is the likely Democratic nominee. But I would not say it's a given. I would say if you're a Republican running statewide in Wisconsin, it's never a given that you're going to win.
What does he do in 2014? He obviously has to run and win re-election. The broader the margin, the better. But does he also go around and try to pick up IOUs, help fundraise for other candidates? Should he start getting into national issues? If you were advising him, what does he do in 2014?
Well, I think that's a very tricky question because you don't want to be doing so much of that your voters back home start thinking you just see them as a stepping stone. And I think he's going to probably be pretty careful not to do that. And if he doesn't, go around the country campaigning for other people, I think that he's got a good explanation for that, which is he's got his own re-election at home to tend to. and that he helps the National Republican Party by pulling Wisconsin in a red direction, to use the modern way of coloring the map.
Red for everybody out there, of course, is Republican. Blue is Democratic. Somehow they've inherited those colors, I guess, right?
That's right. That's right. I think, though, that he has to find discrete ways of broadening national profile, so he's not just seen as the anti-labor union guy, because I think that is a potential element of a successful appeal by a conservative candidate, but you don't want to be reduced to that. I think you've got to have a broader reform message.
So what would you advise him to do to broaden that national image?
Well, I think I would talk about other places where I've been successful. I would talk about how those labor reforms have affected public education in the state of Wisconsin.
Is he a believer in school choice?
And that's something that I think the answer is yes, because he was the county executive, and he's been the governor in a state with one of the most developed school choice programs around, the
Milwaukee, right?
School choice program that's been around for over 20 years.
So you think he's a believer, but it's not something...
Sure.
Yeah,
okay. I'm not 100% sure, but I'd be pretty confident.
He should be going out there, though, developing it, so you and I knew his position much more than we apparently do, right?
That's right.
It's not our fault. It's his job, right?
Well, that's right. And he does have a new book out, Unintimidated, I believe it's called. I have not yet had a chance to read it, but I'm sure it goes into some of that.
Have you had a chance to sit down and talk with him personally, one-on-one?
In front of an audience, I interviewed him at one point, and I spoke to him a second time in front. I was with a group of reporters, and I got to ask him one or two questions. And the impression I get is one. I guess if there was one word that I would use, it's solidity. That he does not strike me as a flashy guy. But just as a very kind of solid citizen, which might be in persona a nice contrast to the incumbent, and also a nice contrast to Governor Christie.
Now, does he have what they call the gravitas to run for president? Does he have a presence? You were sitting here, talking to him one-on-one, asking him some questions. Did it strike you he had that presence, and also does he have the TV personality? Two very important things, right, for somebody running for office.
I think that's an open question. I think those are open questions, and they're going to do a lot to determine how successful he is.
Let me switch over to the conservative movement. I mean, you're involved in that. You write in this milieu. You've got a lot of friends, I'm sure, who are, what do we call them, conservative public intellectuals. People like Bill Kristol. I don't know, come to mind. Who else? Who are the other current idea people? Obviously, you're one. Who are your colleagues who are public intellectual idea people? Conservatives.
There are a lot of...
Give me 5 or so.
There are a lot of conservatives out there who are doing good work about what the future of conservatism should be and what our agenda should be. I think Yuval Levin, who edits a journal called National Affairs, and has a new book out about the origins of left and right, is a tremendous thinker who's exerting a real salutary influence on the right. I think Ross Douthat at the New York Times is a very smart guy who's had a lot of interesting things to say. And I think that there are many other folks. I think my colleague at the American Enterprise Institute, Tim Carney, has done a lot of work on the question of crony capitalism and how we need to distinguish between the free market and things that are in the interest of politically connected businesses.
So what, in your view, what is the essence of the conservative movement now in 2013?
Well, I think that the conservative movement has well-defined and articulated principles that are the right principles, and those include a preference for free markets over government, for national strength and assertiveness, and for traditional values. But what is, I think, in question is how we translate those conservative impulses and principles into a workable agenda for the present day. And I think that's where the work has to be done.
So is that the old three-legged stool that Reagan talked about? Economic strength, military strength, and traditional family values?
Well, yes, and I think those things are...
So there's no change.
I think
We're
the
back.
right principles.
The 1980s are just as applicable now as they were then. So when we talk about the conservative movement of 2013, we go back to Ronald Reagan.
Well, I think circumstances changed.
The applications are different.
The circumstances of this country are not the same as the ones Reagan faced in 1981, and so our agenda has to be different from his agenda. But they can reflect the same timeless principles.
That really concludes our time, and I so much thank you. I'm going to close, but I need to ask you one thing. You are at the Institute of Politics at the University of Chicago in Hyde Park. We are taping this here on December 3rd, 2013. Just give me your impression. It could be like 30 seconds. As a fellow and spending time here at the University of Chicago, David Axelrod's Institute of Politics, what did you get out of it?
Well, it's exciting to be part of the first full class of fellows and to be in on the ground floor at the launch of a new institution. I've really enjoyed meeting these earnest, idealistic students and helping them, I hope, see conservatism for the first time in some cases, and in other cases deepen their existing conservatism.
I very much want to thank Ramesh Ponuru. He, of course, as I said, is an institute, is a fellow at the Institute of Politics, University of Chicago. He's a senior editor of at National Review, a well-known, long-standing conservative publication started by William F. Buckley.
That's correct.
Okay, many, many years ago, and you are also with the American Enterprise Institute, one of the best think tanks around, conservative think tanks based in Washington, D.C. I hope you'll come out and see us again when you're here in Chicago. Thank you so much, Ramesh.
You're welcome.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.
Next from Springfield, we talk one-on-one with Stephen Phillips, president of the Illinois Trial Lawyers Association. We get his perspective on proposed legislation that would expand the rights of citizens to sue for damages under certain conditions, and we get an overview of how trial lawyers operate their business and what criteria they use in deciding whether to take a case. This runs about 40 minutes.
Stephen Phillips, president of the Illinois Trial Lawyers Association. Thanks for joining us on the Illinois Channel.
Well, thank you for having me, and thank you for having the Illinois Trial Lawyers Association.
When we are talking about the trial bar, often everyone is infamous for telling lawyer jokes and complaining that lawyers sue too many people, and often they point their fingers at the trial bar as far as doing that. But I wanted to get beyond that caricature and get into your thoughts on what is the purpose of the Trial Lawyers Association, but also what some of the issues are that you may be focusing on as the legislative session is coming into its heyday here in the spring of 2014. Let's start with the legislature. What are some of the issues that as an association you're focused on?
Globally, one of the issues is, probably the major issue is, we want to maintain the right to trial by jury in the state of Illinois. And when I say that, the right to trial by a fair jury, an unbiased jury, an unprejudiced jury. And we want to make sure that the little guy, little people in the world, have the same access to the courthouse doors that big corporations do and special interests. That's globally our mission of the trial lawyers. Because the court system is the only place that the little guy, the Joe man on the street, has the opportunity to seek justice. And it's a really special thing. This year specifically, legislatively, we're focused on 4 different things. One is that we want to make sure that automobile insurance carriers are on the same level playing field as their insureds, their premium holders, their policy holders. And we want to focus on the fact that when a person makes a claim under their underinsured and uninsured motorist insurance policies, which they've paid a premium for that protection, oftentimes for many years, well, the contracts are written so that the policyholder has to demand arbitration. And there's 3 independent arbitrators appointed, which is fine. But the way the policies are written, that a policyholder can go through the arbitration process and spend money on depositions, on expert witnesses, on other witnesses, and gather evidence. They go to arbitration. Everybody gets their day in court, so to speak, through the arbitration process. Everybody's heard, All the facts are on the table. But in many circumstances, after the arbitration award is rendered, the insurance company, and only the insurance company, is allowed to reject the award, of which they had agreed to participate in, and force the injured plaintiff to file a lawsuit. And that's something that we viewed as completely one-sided and completely unfair to the policyholder, the person who's paid the premium to the insurance company.
Now, who came up with those rules that it would be that way?
People don't realize that insurance policies are contractual. And when an insurance company issues a policy, people generally don't read the fine details of the policy.
And if they do, they probably don't understand it.
Exactly. And what it does is unilaterally, the insurance company can reject the arbitration award if they think it's too high and force the plaintiff to spend money, file a court case, go out, go through the legal process in the courts, despite the fact that they've already done that in arbitration. By the way, the policyholder, if the award is too low and he or she is unhappy with the award, they do not have that option to reject it. Doesn't sound fair.
I know you said 4, so I don't want to get bogged down in one. What are some of the other points that you're focused on?
One of the other areas that we're pursuing is presently if a person is rendered disabled, mentally disabled, as the result of an accident or as the result of medical negligence or lawyer negligence or any negligence, construction negligence for that matter.
Would it have to be deemed negligence?
Well, as a result of what's called...
Could someone have a stroke and be mentally disabled, or is that not?
Well, that's where we're going to get. Right now, the way the status of the law is that if the tortfeasor, the wrongdoer, renders somebody mentally incompetent as a result of their negligence, the statute of limitation is stopped. That claim does not run. The person does not lose that claim so long as they are mentally disabled. If they become competent again, the statute of limitations starts running. Well, there's a loophole, and it's a loophole that happens very rarely, but it's very severe when it does, that if a person, for example, an accident victim, an injured person injured in an automobile accident, 8 months later, 10 months later, becomes disabled as a result of a stroke, something unrelated to the accident, and they're rendered incompetent, and nobody catches the fact that no lawsuit was filed, they would lose that claim. So right now the trial lawyers have said what we want to do is that whether you're disabled as a result of the tortfeasor's negligence or some other disability that occurs afterwards, we don't want the tortfeasor to escape having to pay for the damage they caused, which is what the present state of the law is. As an example, and it sounds complicated, we had a man who was injured in an automobile accident, and his family took care of him for 1.5 years and tried to negotiate the claim with the insurance company directly. Then the man had a stroke, and while the family was caring for the stroke, the statute of limitations had run and they never went to a lawyer because they thought they were going to get the claim worked out with the insurance company. Unfortunately, the statute of limitations had run, and it had run because no one had contacted a lawyer within the 2 years. Well, they were busy caring for their disabled father from the stroke, which is what they should be doing, and the original driver, we couldn't file a claim against the original driver from the original accident because the statute of limitations had expired. And it's just wrong. If he had injured him from the beginning and caused the disability, he would be held liable. By sheer luck, he got off the hook, so to speak, because of the technicality that the person was rendered under a disability, a mental disability.
And what are the other two that you're looking at?
The other two is when corporations cease doing business, we want to make sure that they leave a registered agent available to receive service of process. For example, if a corporation, their conduct is negligent, we want to make sure that when they cease doing business, there's still going to be insurance that's going to cover the negligent acts of the corporation. We want to make sure that the injured person can still collect the insurance that was available prior to the time that the institution closed down.
I want to come back to that one, and number 4 is what?
Number 4 is an interesting and very harsh result when people hire safety committees to come into factories and workplaces to give opinions about safety recommendations and
Kind of as a consultant.
A consultant.
Okay.
What happens is that if there's an explosion or someone gets hurt in that factory because of the negligence of the safety consultant, there's a law that says that the safety consultant doesn't have to answer in court for the negligence, for the injuries that their negligence has caused, because they can come in and say, well, wait a minute, I'm under the workers' compensation insurance policy of the employer. Technicality. You can't sue me for my negligence, and the only remedy the worker has is under workers' compensation, where the benefits and the claims that are due, the damages that are due, are significantly lower and not fair and not full compensation for the injured person. So we're going to address that when the consultant doesn't pay any of the insurance premium, doesn't have anything to do, they shouldn't be allowed to benefit from the employer's workers' comp.
On the corporation aspect of it, if a corporation closes down, one would think that typically they would be closing down because either economic reasons, they can't make a go of it anymore, so they're closing their doors, or perhaps somebody was incorporated and they retired. Where would the financial assets come from to continue to pay an insurance policy to have a liability program in case they were to be sued after the fact? And for how long would that policy have to be in effect?
Well, for the time period that this bill is not dealing with insurance per se. There's insurance out there, and that's covered by different bills. This strictly has to do with how we can get the corporation into court to find out if they do have insurance or assets and how much. This is just...
And right now you can't get them in the court? Or is it?
When there's dissolved corporations, there's an awful lot of hoops, calisthenics I call them, to get through just to find out insurance information and any asset information. And this tends to come up oftentimes with latent disease cases where there's some type of conduct that causes a disease or latent disease down the road. And we just want to make it a bit easier to make sure that we can get the information about insurance assets to find out what's out there potentially for the injured person.
When you represent someone and you would allege negligence, as you were talking about, and your fourth example is an example, or any number of cases, I guess you're suing someone because, well, frequently because it might be negligence. Who defines negligence? Who would say, whether it's the consultant, as you were talking about, or in some other case, who is to say on that question of negligence that there was negligence? Is that the court ultimately? But even as far as just the bringing of a suit, how do you determine if someone was negligent to bring a suit to begin with?
Well, negligence has long been defined as what a reasonable person would do or would not do under the same or similar circumstance. And that's a general good definition. In that scenario, that's what we have to prove in a court of law. There's precedent through other cases, and when lawyers look at determining whether to file a claim or not, they do it with the eye of looking under that standard, that definition, with whether or not they can prove the claim. And I'd just like to add that we've heard the phrase frivolous lawsuits for years and years, and trial lawyers do not file frivolous lawsuits. We can't afford to. We're going to hold a case for 3 or 5 years. It's a long time.
Is that a typical holding period?
Yeah, absolutely. Maybe longer. And we're going to spend an awful lot of money trying to get justice for our clients. It is not unusual for a trial lawyer in a complex case to not only hold the case for 3 to 5 years, but to put in anywhere from $100,000 to $300,000 of our own money into a case on behalf of our clients to make sure that we can potentially prove their case. So if we're going to work on a case for 3 to 5 years, and our office overhead, I'm a small businessman too, continues to run with salaries, my insurance costs, my rent, neither me or any trial lawyer wants to end up on the losing end of a case that shouldn't have been filed. It's not in our interest. Now, the reason that our fees are often contingency and that we charge a third is because, and I say this to my clients frequently, I say the insurance company lawyers are getting paid $250 to $500 an hour. And at the end of every month, they send a bill to the insurance company for $5,000 to $10,000. Would I be able to send you a bill at the end of every month, despite the fact that you're hurt, you're not working, you got medical bills, you got bill collectors after you, and I'm the lawyer now who you hired to seek justice for you is sending you a bill for $5,000 to $10,000 at the end of every month?
So you're going to take cases, one would think, I don't want to put words in your mouth, but you're going to assess the case as a business person and as a lawyer and say, is there a reasonable expectation that you can win a case based upon the facts as they were presented to you and whether or not there were negligence? So I think you would say that you're not going to take cases where you don't perceive there to be negligence, otherwise you'd end up wasting your time and money.
Absolutely. And the trial lawyers are against frivolous lawsuits. And we've always been. Hang on one second, if I may.
Go ahead, sure.
I just think the word frivolous, it goes both ways. And what the public never hears about are frivolous defenses to legitimate lawsuits. And the public never hears about the fact that when there are legitimate cases filed, that oftentimes the insurance companies will file defenses that are frivolous. And cases go on for years in an effort to wear down the plaintiff into accepting less than fair compensation. And I can show you a significant number of cases, which we have here at the trial lawyers, where these frivolous defenses, where cases are settled after years on the courthouse steps that should have been settled years before and resolved. And the public never hears about those frivolous defenses. And I think if the public were to read the examples that we have and what really goes on in the court system at times, this word frivolous goes both ways.
When you hear people talking about the trial bar, what is a common misunderstanding that people have about your industry?
One, frivolous lawsuits. Number one, I hear that a lot. Number two, I often hear that we're ruining business in Illinois or impairing business in Illinois. I live in a fairly conservative town, and I'm often at weddings or dinner functions, and people will come at me, what do you do? I'm a trial lawyer. And you would think that I'm public enemy number one. And when I start telling them the facts, rather than the myths, rather than the perpetual story after story that just keeps spinning, they look at me and oftentimes, wow, I never knew that. Really? That's how things work. And I tell them, for example, right now workers' compensation is a big issue in Illinois. And I tell them, I said, do you folks realize there's over 330 workers' compensation insurance companies writing business in Illinois? And in this hellhole, in this bad place for business? Well, these insurance companies, these 330 insurance companies are climbing over one another to collect premium dollars from employers. And I tell them with regard to workers' comp, back in 2011 when the workers were asked to give up long-held rights, they said, if you think this is going to lower insurance premiums, you're naive. But what we're going to do is we're going to ask you to put in the bill transparency in insurance premiums. And we want an industry watchdog, not consumers and not the trial lawyers, monitoring the payouts under the new law and monitoring insurance premiums. And as the workers predicted, this year, the watchdog, the industry group, recommended a 14% decrease in insurance premiums to employers for workers' comp. because they said that the insurance companies have saved over $350 million as a result of these changes. And you can imagine what the insurance industry said. Nope, not going to happen. Another common myth that I hear all the time, because I do a fair number of medical negligence cases, is that doctors are getting sued right and left. It's not true. And I said, you know, let's talk the facts for a minute. This is all public data, by the way. In the last 10 years, medical malpractice filings are down by 40% in the state of Illinois. That's huge, 40%. And profits are way up in the malpractice premiums. They have record profits, the insurance companies. Another huge myth that I've told people.
Of course, we had the 2004 change in the law that then the Supreme Court threw out as being unconstitutional. But would you say of any of those changes relative to the medical malpractice suits being brought, was that any kind of a change in behavior by the trial bar? And I'm trying to anticipate what someone who would disagree with you would say. Because the bill was like a warning shot across the bow of the trial bar to say, don't sue as much as you did in the past? Or were there other reasons why we had a 40% drop?
The main reason is, and I can say this because I was chairman of the Medical Negligence Committee for 7 years for ITLA, and I've also been a lawyer who's done this for 29 years. Medical malpractice cases are incredibly expensive. A simple one plaintiff, one defense medical negligence case, I have to budget $80,000 to $100,000 out of my pocket to give my client the ability, expense-wise, to try and prove their case, to give them an opportunity. They're very, very expensive. And that's the driving force behind medical negligence. I should say the main driving force.
Do you find any, one of the things I point out to people when we get in conversations, just as you said you did about the trial bar, and because I've covered a variety of issues, I have a little more insight than maybe the average man in the street, but it seems to me certainly the trial bar is out there and will do to the good side. Sometimes we are nickeled and dimed by an industry. Maybe they are charging us $10 a month on something that they shouldn't have been charging, but they're doing it to 1 million people. No one is going to go to court to get your $10 a month back for the last year. But I would say, that's where you could bring a case, whether maybe it's a class action lawsuit, to make sure that that industry no longer does that, because collectively a trial attorney can make some money out of that and have the behavior changed. There's also regulations typically from government, but there's often not enough regulators to go around just to make sure that people aren't taking advantage of consumers. So again, I would say to the good side, you have the trial bar often kind of being there as the unofficial cop on the beat, because they will go in and bring a suit if they find some aspect of behavior going on within an industry that needs to be corrected. So that's, I think when people understand that, they would say, yeah, I get that. But I think they find that sometimes maybe is the net ever on negligence cast too broadly so that we get the guilty people, but we also include people that shouldn't have been included in a suit. How does one determine negligence? We talked about that a bit, but if, let's say, there was a bus accident, we might say the bus driver was at fault, maybe the bus company was at fault for some reason. Would you look to sue the manufacturer of the bus, or how do you draw that line to say, here's who we target on a suit and here's who we don't?
One always looks and says, after an investigation, after anybody does due diligence, you have to look and say, what is the evidence? What did my investigation reveal? What have I found out as far as who is responsible and why, and how strong is my evidence? And After doing that investigation, a lawyer has to ask, do I have a good faith basis for bringing a lawsuit against this potential person or company? And what people have to remember is that when a lawyer files a claim, cases are thrown out by a judge. A plaintiff's lawyer may be subject to sanctions, monetary sanctions for filing an inappropriate case. And again, I go back and say, why would a lawyer who is going to be shelling out an awful lot of money out of his own pocket want to pursue a claim that isn't meritorious and he probably isn't going to recover? So there are multiple steps in this procedure, multiple safeguards to make sure that the person who shouldn't be sued is either A, isn't sued, or B, is dismissed at some point once the evidence is out that shows that he or she is not responsible. Candidly, no one wants to be sued, but the way our justice system is set up, it says you have to provide information sometimes to determine whether or not you did engage in some type of conduct that did cause harm to this person. And the best example I can get is last night there was a recall on an awful lot of cars produced by General Motors from '04 to about '07 or '09. And General Motors apparently, based on the written records, knew about this and didn't recall these vehicles and didn't let consumers know. And a lot of people died and a lot of people were injured. And now, once full disclosure, once the evidence came out, GM is now apologizing to people that they were too slow in responding to the problem with the airbags and the ignition system in certain cars. So this continues to go on. I will say this, that with regard to defective products and dangerous products, in my career, I think it's pretty obvious to me that the actions of trial lawyers have made products safer. Lawyers now filing product liability suits, there's just a handful of lawyers that really concentrate on those now because there aren't as many dangerous products as there used to be when I started this practice 29 years ago. And we've made product safer for consumers because now manufacturers look and say, maybe I better get a safety correspondent in. Maybe I better get a consultant in to look at this product to make sure it's not unsafe or dangerous for consumers.
Do you ever, individually or as an association, do you ever just send a letter out to someone and kind of saying, kind of a heads up, we think that you're having negligence? In other words, are you ever proactive rather than reactive? Do you ever say to somebody, hey, we noticed here's some problem that you might want to address before it becomes an issue?
Absolutely. And I was trained by my father, who was a lawyer for 50-some years, and he had a saying that it's much better to have a fence at the top of the hill than an ambulance at the bottom. So when we see things, when we see issues, we absolutely let people know. And in fact, I have seen, when I've been in hospitals, for example, when I've seen conduct that I think is going to lead to some injury or potentially hazardous, I've alerted the general counsel of the hospital who I may have a relationship. I think you should take a look at this. I think you should have a talk with this person. I'd much rather see people safe and people healthy than have to represent them later on. Because candidly, and I say this about all my clients, every one of our clients would much rather have their health than any money. There's no question.
How much of the speaking of health, and I think when the issue of the Trials Lawyers Association was at its zenith, and at least in recent memory, was back in 2004 when we were engaged heavily in the medical malpractice debate. Is there any, do you know the numbers off the top of your head? I'm just curious, how does it break down as far as caseload? Is it suits involving transportation, suits involving medical malpractice, suits involving maybe being ripped off by some business practice? Is there any pie chart of what a typical or how typical cases are within the industry?
I'm so glad you asked that question. That's a myth that I've had to dispel to all my friends over the course of the years. Globally, and this is a statistic that I think is very telling. About 70% of all lawsuits that are brought in the civil justice system are businesses suing other businesses or individuals for money. Contract dispute types of things. 70%. About 20% or so are domestic relations, divorce, child custody, things like that.
No, but as a trial attorney, you don't take those kind of cases?
No, we do not. We represent injured people.
I guess my point was within the kind of cases that you would take, I didn't know what a breakdown would be.
I'm getting there. I'm getting there. Tort cases, injury cases, make up about 6% of the cases that are filed in the court system. About 6%. Very low, to say the least. Within that, the vast majority of those are automobile accidents, things like that. Of that 6% globally, only about 5% of that 6% are medical malpractice cases. So when you break down that pie chart and you look at 100% of the court cases, 6% are tort cases. 5% of those, that 6% are malpractice cases. You see that the numbers are very, very low as far as medical malpractice, for example. Product liability cases are significantly lower than that. I don't have those numbers, and unlike my opponents, I'm not going to make up numbers that I don't have.
What would you, I mean, what would be the preponderance? Do you know offhand?
Oh, I would say automobile cases.
Automobile
cases.
Yeah. Someone driving in a negligent way and causing some injury.
Or truckers. One thing that negligent trucking cases, truckers drive over the amount of hours they're supposed to have. There's on-duty hours, off-duty. There's log books. And people don't realize that trucking accidents are often due to being overworked by their employer and fatigue. That's why we always look at log books. And we always look at log books against the receipts of where they're buying gas, where they're making phone calls, where they're paying tolls, to determine if the log books are accurate.
On the other hand, a famous incident, I would say, that is in the news now and may be happening again, and it goes to the point you were making when you talk to people and the mythology, and people were saying that you're always suing every people. But as a society, we can become victimized in ways that we never anticipated. And so one of the famous cases is having your credit card ripped off through a department store that maybe didn't have the security. On one hand, the department store themselves are victims of criminal activity, but perhaps they would have had some degree of negligence if they should have known that their credit card processing was more open to being hacked than it should have been. Is that an example of a kind of case where there's a new area of law that your association members would be going into?
I haven't heard anybody talk about that, mention it to me personally. I would hope that the manufacturers or the retailers or whoever's holding credit card information or personal information is going to beef up their security. I had a chat with a security expert over the weekend with regard to that issue, and he said that he had predicted it along with a lot of industry insiders. But as far as the trial lawyers, I can't speak to that because I haven't heard from members.
Before we close out, how is your industry? What's the health of your industry? Are more people coming into your industry? Is it getting harder to practice? How would you assess it now?
That's an interesting question. Unquestionably, our industry is, and in fact, I would say our profession, because I don't like to think of it as an industry. Our profession is always difficult because we are constantly responding to the manufacturers, the United States Chamber of Commerce, attacks, well-moneyed attacks on the civil justice system and the laws, because it's their mission right now to see if they can pollute or bias the public against trial lawyers and against injured people. And so in that sense, our profession has gotten very difficult because they're much more organized now and they're relentless with their daily attacks. And they never let the public know that 6% of cases are tort cases. If you buy into their constant daily rhetoric, their constant daily attacks, one would think that 90% of all lawsuits are injury cases, when just the opposite is true. And they perpetuate the McDonald's coffee cup myths, for example, which that's one of the things as the trial lawyers that I've explained to people how that happened and when they hear the facts. When people hear the true facts about the coffee cup case, their eyes open up and they say, wow, I didn't know that. And I'd be more than happy to share that with you if we had time. That lady was not driving the car. She was sitting. The coffee spilled on her when she opened it up. She had third-degree burns in her crotch. And I've seen the pictures, and I show people the pictures. It looked like she had battery acid dropped in her crotch. From her crotch halfway down her thighs, it looked like she had battery acid. She got hit with 180 to 190 degree coffee, which on your body, all the burn experts will tell you, you have 5 to 7 seconds to get that coffee off. Industry standard is 130 to 140 degrees for coffee. And when that coffee spills on someone, they've got about a minute to get it off. Their clothes, pull it away, take off their clothing, whatever. Well, McDonald's had had 700 prior incidents of their coffee spilling on people and causing serious burns. Kids, seniors, people who weren't quite perfect and happened to spill some of their coffee. But they kept their coffee that hot because it would last longer. So the jury heard all this evidence, a common jury under the 7th Amendment of the United States Constitution, right to trial by jury, and said, you know, we're going to give her $480,000 of compensatory damages. And we're going to reduce that by 20%. I'm sorry, I take that back. The jury gave her $200,000 in compensatory damages. $200,000. And they reduced it by 20% because they said 20% of this accident, despite the fact that this coffee was scalding hot like acid, was her fault. So her award was $160,000. And then they turned around and said, you know, McDonald's, you did 700 prior claims, and we're going to penalize you with punitive damages for $2.6 million, which represented about 2 days' profits from coffee sales for McDonald's. That's where the numbers came from. And the judge turned around and said, you know what? The $2.6 million in punitive damages is too high, and he reduced that award to $480,000. Those are the true facts behind the McDonald's coffee cup. Not that a lady just spilled a cup of coffee and got $1 million.
I know we can't, we could go into a lot more details and talk at length, but relative to one of the points that you had made right off the top, that you wanted to maintain the jury, trial by jury or decision by jury, why is that under threat? What's afoot that we would not have trial by jury?
Well, there's a big push by the United States Chamber of Commerce and insurance companies, number one, to put arbitration agreements into an awful lot of contracts and to send cases like this to arbitration. There is a huge push to enact special laws, special legislation, to impair the ability to bring a claim to a jury and impair the evidence that the jury will hear. And then to put caps on damages and say, you know, juries don't know enough. Juries aren't knowledgeable enough. We want to put arbitrary caps and set damages at a fixed amount regardless of the evidence and say to the jury, this is as much as this injured person is ever going to receive. And that's a threat to the jury system. That's the right to the constitutional right that taxpayers have to seek redress in the court system that their tax dollars fund.
You know, you just brought up, and I apologize because not to go on too long here, but when one goes to a stock house, almost any stock brokerage company in America these days, you basically have to sign a form that says you're going to have to go to arbitration, that you're not going to be bringing a suit through the courts. Which is a bit of signing a contract under duress, because it invalidates some of the rights that you don't know before the fact how you might have been injured. I mean, look what happened with Bernie Madoff as an example. No one went into working with Bernie Madoff knowing that he was going to be engaged in criminal activity and engaged in thievery. To what extent does one have to, if you sign these agreements, whether it's a stock brokerage or any other industry, saying I'll go to arbitration, do you have to live up to that, or can you get a trial attorney to say it's somewhat invalid because there's really no other option for the person to even get into the services, goods and services, if they have to, they didn't really get a chance to negotiate that aspect?
The vast majority of these arbitration agreements are upheld, and you have to go to arbitration.
And I'm not trying to put words in your mouth, I mean, is that basically a good process or not a good process?
It's, number one, it's a process that most people are not aware of, because typically it's either in fine print or it's a process people don't understand. For example, you put your elderly parent or loved one in a nursing home, and now the nursing homes are throwing arbitration agreements into these agreements. And that takes away a constitutional right that our forefathers fought for and thought was very important with regard to the foundation of this country. You know, the Seventh Amendment, the right to trial by jury, is the only thing that really keeps everybody in check. And there's an awful lot of people that never want to be in front of a jury having to answer to jurors with regard to their negligent conduct when they know they've done something wrong and they don't want to face the jury. But that's what our forefathers suggested was the best way.
Is there an aspect of the level of grievance? In other words, let's take a nursing home. If someone wants to sue because they got served some food that maybe had gone bad and they're, had food poisoning and were sick for a while, that might be one thing that you would go to perhaps arbitration. If, on the other hand, a nursing home hired someone who had a criminal activity and ended up doing physical harm against a patient, would you still have to go through arbitration, or is that a level to which it would invalidate and you could bring suit?
That's a slippery slope to start picking cases of this one should go to arbitration and this one shouldn't go to arbitration. As I say to people, I
guess I'm asking, can you pop that veil of arbitration? Is there some outlet for the consumer, in a level of between venial sins and mortal sins, so to speak, as you might say, depending upon the grievance, the level of grievance?
As the law exists now, the answer is no. And I would suggest to people, that's what I call selective constitutionalists, that certain people are allowed the rights under the Constitution, Seventh Amendment, and will make the decision whether
would it be people, or would it be just a level? In other words, like the difference, as we say in the law, between misdemeanor and felony. The law would still apply, but it all depends how it's applicable, not necessarily to whom.
Our concern as the trial lawyers would be, who's going to decide that? Who's going to decide what level of harm should be heard by a jury, should be allowed the constitutional protection of the Seventh Amendment, and who's not? And the problem with that is that people are selecting who should be given the protections of the Constitution and who shouldn't. And that's just not right. The right to trial by jury has been around for a long, long time since this country was founded, and it's served this country well. And to go place arbitrary restrictions, someone says, well, I think this person or this level of harm deserves it, but this one doesn't, would violate those principles.
As we close out, what would you say to someone who's considering about going into your industry?
Go into this profession for the right reason. Either be a student and a scholar, or go in to seek justice, go in to help people, go in and do this for the purposes of doing good for the rest of our population. Because what I found over the course of my 29 years as I get a little older and a little grayer is that I take an awful lot of satisfaction when at the end of the day I've helped somebody who was the underdog. I've helped somebody get justice who was faced with a bleak future, was faced with mounting bills, and was getting the stiff arm from the wrongdoer. And it's a very rewarding experience over the course of a career.
All right, well, Stephen Phillips, we appreciate you taking the time to talk with us.
Thank you very much for having us, and remember the right to trial by jury.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.